Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Today is March 14th. The time is about 5 p.m. Central Time. Every week on Tuesday from 5 p.m. Central Time to 6 p.m. Central Time, we bring in live. You can ask questions and we'll try to answer as much as possible. Rebecca, what do we have today to discuss?
Yeah, so we'll go over the recent USCIS website update that they made regarding the 60-day grace period for non-immigrant visa workers. We'll also go over do's and don'ts for employees who are find themselves in an FDNS site visit, what you should do and what you're obligated to do, what you're not obligated to do. We'll also discuss a common question that we get: does filing in premium processing increase the chances of receiving an RFE or denial for the case? And we'll also talk about ways to make sure H-1B workers who are working remotely can make sure they are complying with DOL and USCIS regulations.
What's there to discuss on the 60-day grace period, Rebecca? Isn't it the language very clear when they updated it this Friday that, let's say, for example, if the person gets laid off on February 14th, but he gets paid until March 14th, isn't it that the language that says that it is the day that they receive the last payment, isn't it clear that the 60 days starts from March 14th? That's when the guy got paid until, because it clearly states that up to the date the wages, salaries and wages are paid. Isn't that clear? Or is there any ambiguity in the way they structured that?
Yeah, so this is a question that people have been kind of asking USCIS for clarification, especially since the engagement call that they had a couple of months ago. And they only recently, this past Friday, updated their website. This is the USCIS website titled Options for Non-Immigrant Workers Following Termination of Employment. So it's kind of an FAQ webpage for a lot of the workers who found themselves laid off in the last few months. And one of the new updates from this past Friday was this question: when does the 60-day grace period start? Because we've had various interpretations before this clarification. Is it the last day that the employee reports to work? Is it the last day of their normal payroll? Is it the last day they receive severance pay? And USCIS's answer was this: the maximum 60-day grace period starts the day after termination of employment, which is typically determined based on the last day for which a salary or wage is paid. So even even within our office, we've had, some discussions about what exactly that date is. Is it the last date the employee reports for work? Is that the last day for which they receive a salary or wage? Whereas in the case of these recent tech layoffs, it's been pretty common that the laid off employees are receiving, 3 months at least of severance pay. Is it, is the last day that they receive severance pay this last day that is being referred to here?
What's your opinion?
Personally, my opinion is that it is the last day that the employee reported for work, because in my reading of it, the last day for which a salary or wage is paid is the last day that they put in hours, that they receive their regular wage.
But I received my last pay until March 14th. Why are you still saying that salaries are paid only until February 14th, though? That's the last day of my employment.
Yeah, so that is more of a question of whether USCIS is going to consider severance pay part of an employee's salary or wage. They didn't specifically address severance in this Q&A update. There's nowhere on the page that they specifically talk about severance pay, but we did locate an old kind of, it's not even really a memo. It's kind of a letter from the old INS chief back in the 90s, where they seem to indicate that at that time, this is pre 60-day grace period at all, but back then at least, the way INS at that time was interpreting severance pay was that they didn't consider the receipt of severance pay as part of employment. At that time, basically their response was that time that you receive severance pay is not time spent in status. And so even though there is this 60-day grace period now, if you kind of apply that same reasoning, it would seem to be that USCIS wouldn't consider severance pay as a salary or wage for employment, active employment. That's kind of my reading of it, but I know that I'm sure there are other attorneys.
I kind of disagree with you that in 2009 letter to the USCIS, they said that, as what you said, is the last day is the day, the salaries and wages, the severance is not considered to be the salaries and wages though. But they actually did not define what a severance pay is. They did not define what a wages and salary is in the immigration at all though. It's just a letter that they stated. Now this website update, I think so, is probably updating us saying that severance pay severance pay last day will be considered. That's the way I am reading it. Because they should have clarified saying that severance pay should not be considered as wages. They should have specified. They didn't specify it. They were being asked this question specifically if the severance pay is. Now, taking the definition from the IRS, of course, I read the definition of the IRS. It says that wages and salaries, severance pay is not considered to be wages and salaries. That's, I got the point. But we don't take the definition of IRS into USCIS. If I were to take the definition of IRS into USCIS, then we should not be even speaking here because they consider all H-1Bs as residents of United States of America. That means they are the green card holders according to the USCIS definition. So they didn't define it. I'm going to stick with USCIS thing and say that the last day is the day severance paycheck has been received. Now, obviously, when I advise the clients, though, I want people to be a little bit more careful. I want you to consider the last day is the day that the employment is terminated. But I will argue for my client that if it is, then the last day of payment, the last day of the severance pay will be the start of the 60 days. Be cautious, guys. There are difference of opinion in ours. We consider that between the February 14th, when you lost the job, and by the March 14th, that's when you stopped getting payment, though, of the severance pay. That is a gray area still after the update of the website, according to our office right now. Anything else, Rebecca?
Right. I would tend to agree. Of course, the strongest position to be in is if you are able to file a new application within the 60 days following your last date of employment. But if I have a client who is in a situation where they tried and are not able to do that, I will definitely still make the argument. I will still try to file the case and make the argument for someone who is filing within 60 days of their last severance payment. And we have filed those cases before, and we have not gotten pushback from USCIS so far when we have submitted just a pay stub that is dated within 60 days of filing. We haven't gotten RFEs from USCIS asking, is this for regular pay? Is it for severance pay? So, I would still, even though I lean towards it being within 60 days of the last date of employment, if that is not possible, I will still file the case, try to make the argument with USCIS.
Rebecca, when FDNS site visit, as people know that when you're in H-1B, they come for a random visit. And right now they're forcing, please answer my questions right now, within 2 hours. By the end of this day, you give me the pay stubs for all these years. You give me all the pay stubs, employment history, W-2 forms, all that information. They wanted to get it done within a period of 2 hours sometimes by the end of the day. And I see that some of the people have told some lies because they were under pressure from USCIS to answer the question fastly. What do you feel about when people come to the FDNS? What should people respond? What should they do?
Right. So if you are unsure of what your answers should be, a policy that is, always a good policy to go by is to just not answer any questions.
What do you mean not answer, Rebecca? Do they have a right not to answer the questions?
Yes, they do. So we have up on the screen here is the another USCIS website. This is a website that is titled Administrative Site Visit and Verification Program. That's the official name for the site visit program. And this second or third paragraph, as you can see, participating in a site visit is voluntary, but strongly encouraged. Of course, they're going to strongly encourage people to participate and give information that is not technically needed, but it is voluntary. So it is, it's not required. It's not mandatory that you, as an employee, answer questions from an FDNS officer or a contractor who has come to your place of work and are asking you suddenly all these questions about your employment, about the company, how you came to the company, other information about the company that's not even relevant to your application. We understand definitely, as you know, you want to be compliant, you want to be maintaining the status. And so it is a natural instinct to want to be helpful, provide the information to this immigration officer who has, you know, come in person to your place of work. But we have just seen so many situations where because of how aggressive or how sometimes confusingly the questions are worded, or just how irrelevant the questions are, there ends up being a lot of information that employees inadvertently give to the officers that are either inaccurate or not relevant to their case, and that are then used by USCIS in kind of a twisted way to make other inquiries. It can just, a lot of times it ends up being more harmful than helpful to not only you, but to the company. So you definitely have the right to tell the officer, I am not comfortable answering your questions. The site visit, you know, it's voluntary for me to answer these questions. You can always direct them to your company's attorney, to the immigration attorney, and you can let the officer know, you know, I will need to speak with the attorney that worked on my case, or direct them to reach out to that attorney. They have the G28 on file. They can see who the attorney of record is, and they can easily contact that attorney. All our contact information is there on the G28. So that is perfectly legal for you to do and within your right to do.
And don't hesitate, guys. Point out to their own website that it's voluntary. And we have given this website link to you in the description of this video. Give them this website link to them and tell them, look, if you are going to give me time, and if you're going to only restrict the questions to my employment, whether it is required a specialty occupation, I am willing to answer. Otherwise, I am not willing to answer. I'm not willing to answer this question. It is a voluntary thing. Refer them their own website. Okay, look, your own website says that thing. You're good. You don't have to worry about it. We see the officers putting a lot of pressure. Give it to me in 2 hours. Otherwise, I mean, they come at a very pressure point. And we want to make sure that you don't answer any wrong information. If you have any doubt, you need to check that information before you give it to them. So don't give any wrong information. Don't hurriedly give it. Don't come under the pressure with the USCIS officer or the FDNS officer. Tell them it's voluntary. It's up to me. Look at your own website. It says it's voluntary. And direct it to them saying that I will do according to my own, or my way or highway. You can tell that guy. Don't be his way. It should be your way or highway, because it's voluntary. Okay? What's the next topic we have, Rebecca?
Okay, so we get this question a lot. If I file my case in premium processing, is it going to increase the chance of getting an RFE or a denial? What do you think, Rahul?
Absolutely not. I mean, this is a rumor that has been going on, that if you file in a premium processing, it's going to get a RFE. We don't believe that at all. We never believe it. The only thing is that it will expedite your RFE. It will expedite your denial, but it's not, there are no higher chances. Of course, there are exceptions. Of course, Rebecca is much more knowledgeable in those. There are some exceptions to it. Can you tell some of the exceptions where you think so that people should not file the premium processing immediately?
Yeah, and this is more of a recent phenomenon. So we're not necessarily saying not to file in premium, but this is just kind of a recent trend that we have noticed because starting at the end of January, USCIS just opened up premium processing with the initial filing for EB1C cases and NIW cases, which historically have not had premium processing available. And just last year, they started allowing upgrades, but January 30th of this year, they started allowing initial filings to be filed with the premium processing. So just in the past month and a half or so, our office has filed some of those applications under premium processing under this new program. And we've gotten RFEs on those cases that it's pretty clear from the way the RFE is written that the officer is not very well trained. On some of them, they get the issue completely wrong. And on some of them, or on actually all of the RFEs we've gotten in the past month on those EB1C NIW case premium processing cases, the officer misquotes facts in the RFE. They are either looking at the wrong file, like they refer to a degree that our applicant did not have at all, that we never mentioned. They referred to an entirely different engineering field than our applicant had. And another one of the RFEs, they misquoted twice within the same RFE a certain date, which was still not the right date. They said April in one place, they said June in another, and the correct date was May, which was clear in our application for the date of acquisition for a corporate relationship. This was an EB1C case. So from that, we can tell that just for these particular cases, our sense is that because this is a new group of premium processing cases, USCIS has brought on a lot of new officers who are not accustomed to processing EB1C and NIW cases in particular, or they're just moving too fast because they maybe got an influx of premium processing requests just in the past month because it's a new program. So for if you are preparing one of those cases, EB1C or NIW, we might recommend, if you are not in a huge hurry, if you don't have, a 6-year limit coming up for an H-1B or something like that, it may be a good idea to file in regular processing first and then upgrade later when we start noticing that these initial kinks are kind of being worked out. I do think that it is mainly just a result of this being a new program, and USCIS probably got a huge influx and brought in officers that are not accustomed to processing them, because they're not even RFEs that we usually saw in the past for regular processing for these categories. So those would be the only exceptions we would maybe mention at this time, but it's also not for, not permanent. We wouldn't say never file in premium processing for EB1C or NIW just at this time because of these trends that we've noticed just in the past few weeks.
That's only for EB1C you're speaking about, NIWs, especially
Right.
when they introduce new premium processings. That's probably, you need to be a little bit cautious, but otherwise we always recommend people, if you want to go for premium, go for premium. Especially for I-140, it's very advantageous for you to go for premium processing. There are a lot of advantages of getting your status rectified before the I-94 expires. So it's always 90% of the time it's more advantageous for you to go premium processing. Yes, there are some times it may not be advantageous, like what you said. Rebecca, this remote work is becoming a little bit problem now. A lot of people think so. Let's say, for example, I have a job in California and I've been working with the LCA in San Jose area. And now I want to move to Dallas. Of course, that's where a lot of immigrants are moving to. And I want to work remotely from Dallas. Why do I need to file an amendment? Is it required? Because I'm just working still in California. Is that required?
Yeah. So if your company is not changing locations, your company is still based in California. But if you are physically moving to Dallas and will be working remotely from your home in Dallas, that situation still requires an H-1B amendment. So USCIS and the Department of Labor, they still go by, even though remote work is fine in the H-1B context, we file a lot of H-1Bs where the only work location is someone's home address, and it's not a problem. But it is still a physical work location is what USCIS and DOL go by. So if your physical work location is changing, even if it's just a change in your home work location, if basically where you are situated is going to change outside of the MSA, the metropolitan area of your approved petition, then an amendment is needed. So even if there's no other change, you're working for the exact same company, the company has not moved, or you're working on the exact same client project and there's no movement in the client, if you physically move, that still requires an H-1B amendment, and that amendment should be filed prior to your home move. So it should be filed and pending by the time you are working from your new home work location.
We see a lot of people violating the status, getting in trouble, and later on the extensions, amendments, or change of employers getting denied, and they have to go to India to get the stamping. Please avoid it. File the amendment. We consider wherever you are sitting should be the LCA location. Now, if you move within 20 miles of the LCA location, you're good. I mean, you're fine. But of course, if your job is in San Jose, you're moving to Dallas, even though you're remotely working, please file an amendment before you move, not after you move. Let's go to questions, Rebecca, unless you have anything else to say.
Nope. We have a question from Shiva on YouTube asking also about premium processing. He says, after submitting RFE documents for the H-1B premium process, how long will USCIS take to give a response? So from the time they receive your RFE response, USCIS will have another 15 days, 15 calendar days to make a final decision on the case. If you are submitting an RFE response for NIW or EB1C, they will have another 45 days. So premium processing timelines just for those two categories are 45 days. But if it's an H-1B premium processing or any other type of premium processing, L1, I-140, they will have 2 weeks, 15 days to make a final decision from the time they receive the package.
Shivkumar also has an interesting question. Do you know how many I-485 applications are pending each year? For the year until December of 2014, what he's concerned in is how do we know that if the 485 applications pending, what are the priority dates? In each month, what the priority dates are. Before 2016, before Trump came into power, though, we used to get the stats. So we would get an idea that how many applications are pending in general, how many from each country, for each month priority date, how many 485s are pending. They stopped giving it, and we filed a freedom of information, but they still did not provide it. So almost like 1 year, maybe they will provide in the next 6 months. We didn't went and sued the USCIS because it's costly for us to do it, but we don't have the stats at this point of time until December. Pakala Prasad has this question from YouTube. Entered an AP class of admission is DA on I-94. Should that be used as immigration status when filing a renewal of the I-765? It doesn't matter. You can either use that, or you can even say that you are entered an your status is H-1B or H-4, whichever is respective. If you have a valid I-797 that is still valid, you can still say it. Either way, they're going to approve it. It's not going to be a minus point for you.
Sue from YouTube has a situation with a B2 extension that was filed for, these are her parents during, it sounds like 2020 during COVID. There were a lot of situations where the B2 extensions were filed because travel wasn't possible. And because the I-539s took so long to process, a lot of times the parents or relatives would depart the US before there was even an approval, which is fine. As long as there was a receipt notice that covered their period of authorized stay, that's fine. However, in Sue's case, they are saying that in their case, they eventually got the I-539 approval, but it was only approved for 3 months instead of the requested 6 months. And so their parents ended up overstaying because they stayed kind of for the additional 6 months they requested, but the approval only came back for 3 months. And that on their subsequent visits, they were only granted 3 months at the border. So there may not be a way to fix this right away. So probably all you can do at this time, actually, I'm glad your parents were able to come in on that same visa. They were only approved for 3 months, you said, but at least they were able to come in. In some cases, CBP may not let people in if they are considered to have overstayed their previous visit, even though in this case it wasn't really their fault. They did file a timely request for a 6-month extension. So I would say in this case, just have your parents stay and depart within the 3-month period that they are granted at the border. And if in the future, I would say, because the officers have discretion at each entry, the officer at the border makes a decision how long that person is able to stay on this particular visit. So it may be that this officer only granted them 3 months because their most recent stay had that issue. If they comply with everything, depart within the 90 days they're given this time, I would say in future visits, it's possible they may be granted up to 6 months if there are no more problems from here on out. So I don't think there's anything you necessarily can do to apply for a longer time. Just make sure they depart before the end of the 90 days this time, and just request 6 months in the future and see if it is granted.
My cousin lost a job, and it's nearing 60 days. Can I open LLC and hire him on H-1B? Are there any issues if I do that? And this person is on GC. I would not recommend. The only purpose for you is to protect him, and you're opening the company. That's definitely is not a good idea at all. But if you are in general wanting to do a business and it's falling in line in that particular business, so then that's fine. But if your only purpose is to save your cousin, there are other options. We said if you lose the job, if you're nearing 60 days, what are the things that need to be taken care? He can apply for F1, he can apply for B2, he can even look into, if he has an I-140 approval, to look into compelling circumstances EAD. But just for the purpose, I do not want you to do.
So Momo had an I-485 pending, and while it was pending, their employer was acquired by another company. So they're asking, will that have any impact on the green card, and does a supplement J need to be filed? So basically, if the I-485 was pending for at least 180 days, there shouldn't be any problem. The new company can file a supplement J if they want to, but it's not necessarily required. So we saw the past couple of years, USCIS was not necessarily requiring a proactive J supplement to be filed by the new employer, as long as the occupation is same or similar, the job offer from the new employer is same or similar. If the acquisition happened before the 180-day mark that your I-485 was pending, you'll need to probably or have an immigration attorney do a closer analysis to see if the new employer is considered a successor in interest to the first employer, and then figure out what may need to be filed there. So that will be kind of an important point for you to look into, how long the I-485 was pending at the time the corporate acquisition occurred.
I learned from our in-law. That's his name. He has a question with regards to, he's a U.S. citizen. He's turning 21. His parents, his father is an H-1B, his mother is an H-4, his younger sibling is an H-4. So he wants to file for his H-4 mother the green card, but not for his father and not for his brother. That's a very nice plan that you're planning. Because if you file for a green card for your father and he lets his H-1B go, your brother will become illegal. So definitely that's a very good option to file only for mother at this point of time and not file for your father. Now, his concern is that he doesn't have an income, his mother doesn't have an income, of course his father has good income. Could he use the father's income to supplement the income requirement for the sponsorship? I would advise against it though, because your dad is not a green card holder, neither he is the beneficiary of the green card application though. You can find your cousins, uncles, or anybody that have the financial resources and who are green card holders that can supplement the income. It's called I-864 supplement form. They can file that information, and they can file for the supplementing the income of you, that would be in your best strategy instead of using your dad, who is an H-1B person.
Avinash is asking, is concurrent approvals still happening for H-1Bs, H-4s, and EADs filed all together? So the policy now after January of this year is supposed to be that H-1Bs, H-4s, and EADs filed all together should be approved together. That is still the official policy, although we know in practice it is not always happening. And Stephen Brown in our office, the head of our litigation department, who was, part of that lawsuit that brought about that policy change, has been in touch with the U.S. attorneys that were part of that settlement to follow up on so we are kind of gathering specific cases that we are noticing where it's not being approved altogether. What we've heard from the government side so far, it appears to mainly be not necessarily a matter of USCIS not honoring the settlement or not going according to the policy. It seems to be more incompetence or just kind of on the ground. They're still taking time to implement the policy. So we know it is not always happening in some cases at the moment, but it sounds like USCIS is working towards making that happen for all cases going forward. But if you have filed recently and notice that it's not being approved altogether, you are not the only one right now. And if you do hear of a case like that, we recommend you can just send a quick email to Stephen Brown in our office. He is kind of gathering some example cases to notify the U.S. Attorney's Office of those situations. Okay, we got another question from Hari, who is having an H-1B registration filed for him in the lottery, which is going on right now. It will close this Friday at noon Eastern time. So if you haven't had your registration done, make sure to get that completed by your employer and their attorney if they're working with one. Hari's question was that when his H-1B was registered, there was a typo in his first name. Basically, some additional letters were added inadvertently, and he's asking, does it cause any issues? It might, Hari. So actually, at this time, if you have noticed that error, right now there is still time to do something about it. So I would recommend that. Basically, even if a registration has already been registered, paid for, and submitted, at this time, before March 17th, there is still time to delete a registration and submit a new one. So in your case, Hari, I would recommend that you have your employer work with their attorney, if they're using one, to delete the registration for you that has the error in it and immediately submit a new one. There is a way that it can be deleted, even if your registration is part of a group of others for that same company. They can remove just a single person's registration without it affecting the others that were part of that batch. And then they can just do a new form registration for you on your own. They'll have to pay another $10. They won't get those $10 back, but I would say that's fine. I would rather, pay another $10 and make sure your registration is correct without typos. If for whatever reason that is not possible and it gets past March 17th and your registration is still there with the typo in your name, there is a way that you can, if you get selected, you can have your attorney or employer explain the typo if they're filing the application and hope that USCIS will not have a problem with it. Most likely they won't if everything else matches up with your passport number, your date of birth, and everything else. But I just would rather not be in that position to have to ask USCIS's discretion. So while there's still time this week to fix it, I would ask your employer to fix it.
I learned from RN Law Group has a further question. What if he adds the dad, but he will not add his brother because brother cannot be included in the immediate relative? Can he use the dad income source? Will that be a problem in filing the 485 using the dad income? Absolutely not a problem. You can use the beneficiary's income. Absolutely, in your dad's case, you can use the dad's income to supplement it. We have done it several times, no problem, none at any point of time. Question that comes from Deepak Singh. This is very important question, guys. I want you to listen very carefully, though. There's one child who got stuck in India because of this reason. I want to explain what the situation here is. When traveling, this gentleman question, Deepak Singh question is that he has an advance parole approval, which he got it in January of 2023. That's valid until January of 2025. Now, when he traveled, when he came back, the validity on the online system says that he can only stay 1 year. So if he comes back in March of 2023, he's saying that they can only stay until March of 2024. Ignore that. Only one time the I-94 we tell you, please ignore it. You can stay here after that period of time too. Absolutely not a problem. Rebecca, this is what happened with one of my clients though, is that they actually stamped the approval of the advance parole. He had this child in the similar situation. Let's say, for example, the person's advance parole was approved from June of 2020, June of 2021 to June of 2022. He traveled, he came back in October of 2021, but the I-90, they stamped the advance parole saying that he can stay until October of 2000 and he can stay for October of 2022. Let's say October of 2022. So, but his advance parole was expiring in June of 2022, but his on the advance parole, the CBP upper stamp as if that is expiring in October of 2022. So he traveled in July of 2022 and he was trying to come back. The Emirates stopped him, said, you can't come back. He showed the advance parole. Look, in the advance parole, the approval, the CBP approval says that it is valid until October of 2022. Why can't I travel? The Emirates people and the CBP pointed out, look, the advance parole validity is only until June 2022. You cannot enter. The kid is stuck there. The rest of the family can fly in, but the kid is stuck there. Ignore the instructions that you have been given by the CBP officers when you come in advance parole. Ignore it. Only the USCIS counts here, not the CBP. That means the I-94 there you ignore. Only this time. Only this time. Not any other time. Only this time. Ignore it. So the advance parole approval date is relevant. In your case, the person, you're fine. Your advance parole is still valid until January of 2025. It's valid until January of 2025. You're absolutely fine. You can still travel on that one.
Nigel has a question. As an H-1B holder, can he start an LLC to purchase long-term rental real estate and run it without having a property manager? So, Nigel, if your only status is H-1B, if you do not have an EAD, advanced parole, if you don't have an I-485 pending that gives you an EAD card, then unfortunately, as an H-1B visa holder, if you are managing property and receiving income as a result of your work managing rental property, that is probably going to be considered by the government as unauthorized employment, because when you're here on an H-1B visa, you are only authorized to be working for the H-1B sponsoring company. Investment is allowed as an H-1B visa holder, but only passive investment, which means you are only investing the money, but you are not doing any activities to manage that investment, as in managing the property. So the kind of classic example of passive investment would be buying stocks, buying and trading stocks. Even if you spend a lot of time doing it, that is not considered unauthorized employment, because the money you are investing is just investment without, you have no say, in the operation of Apple or Tesla or whichever stocks that you are buying. You're just investing the money and taking a return on the income if there is any. Anything where your investment is going to require hands-on labor to manage the investment, you would need to hire a separate property manager or someone to run your LLC on your behalf, someone who either has an EAD or a green card or a U.S. citizen. So if you have, so in these situations, a lot of times what we end up seeing is for families who are in this situation, if you have an I-140 approval and your spouse is on H-4 and they can apply for an EAD, then the H-4 EAD holder can be the head of the LLC and manage the property. That is fine because the EAD is unrestricted, but you should not. You should not do any activities related to that to avoid any impression of unauthorized employment.
Slow Sali asked this question. Can a H-1B holder make money on social media platform like Instagram or YouTube? The answer is no, unless your job profile is to make money on YouTube or Instagram. That means that you're being hired to do so. In that case, also the income should go to the company, not to you. So no, because you're actively working. So for example, if we are making this YouTube, I'm working for Reddy Neumann PC. So that's an active involvement in there. Now, if it's a voluntary thing where you're not making any money, absolutely not a problem. And if you have a hobby, for example, to make YouTube videos, cooking, people have hobbies, absolutely not a problem. But once you're converting into money, that is becoming working. So that definitely is not allowed. A question that comes out with Saptasri Chakraborty on the line of change of location within the same MSA. Will that consider to be a problematic in the remote work where you said that when you change the location, you are supposed to file an amendment? No, Saptasri, in your case, you do not have to file an amendment if you are working remotely or you change within the same MSA. You're perfectly all right. You do not need to file an amendment. So if you're moving from Dallas to Irving or Irving to Frisco or Dallas to Frisco, it's within the same MSA. You do not have to file an amendment. Even though you work remotely, you don't have to. It's only when you're moving from San Jose to Dallas or Frisco, that's a problem. But within Dallas to Frisco, for example, it's not a problem.
We have a couple of questions about entering at the ports of entry. One question is, after you obtain the green card, what's the significance of the I-94? So you don't need an I-94 anymore. You don't need to check your I-94 anymore. Once you have a green card, you're allowed to stay here permanently. So you never need to go to that I-94 website again once you have the green card and are a permanent resident. We have another question that asks, is a photocopy of the I-797 approval notice acceptable at the port of entry? Yes. So you no longer need the original I-797 at the port of entry or at the consulate. Actually, ever since the pandemic, really a few years ago, the agencies are no longer requiring the original I-797 approval notice. A photocopy has been absolutely fine. Really, the only time that we're still aware of that you need the original approval notice seems to be if you are trying to renew your driver's license. DMVs, and it depends on your local DMV, it varies from state to state, but it does sound like most DMVs are still requiring the original I-797 approval notice with the I-94 card attached at the bottom in order for them to renew your driver's license. So that seems to be the only time you will still need that original.
Adain Soganasi has this question. Is automatic revalidation allowed when you have an alcohol misdemeanor? I would recommend you to consult a lawyer, though. Don't do the automatic revalidation. I'm going to explain what an automatic revalidation means. Let's say, for example, if your passport, visa, and H-1B is expired in September of 2022, but your I-797 is expiring in 2024, can you travel to Mexico or Canada and come back? Will that cause any problem because your visa is expired? If you travel within 30 days to Mexico or to Canada, you can come back. You don't need a passport stamping to come back into the United States. But when there is a criminal conviction, we recommend that other than regular traffic tickets, please consult a lawyer before you do any of those steps. The question that comes in from Narendra Reddy, it's a good question that comes on the FDNS. Do USCIS go to home address for FDNS site visit? I'm not a remote employee. Yeah, we have seen that. I don't know why they do it, Narendra. But yes, they do. They try to intimidate and try to extract some wrong information from you. And yes, they do. We have seen them going to home, and you can tell that, my way or highway. Come and have a tea. I will serve tea, but I'm not going to answer a question. You can do that. Absolutely, you can do that. You want to taste my tea? You want to eat my biryani? I will serve you, but I'm not going to answer. You can do that. You can absolutely do that. You can do my way or highway. Believe me, follow this one in the FDNS. My way or highway, you will be fine. They have to behave according to what you tell, otherwise, you are not cooperating. Eat my biryani, I will answer the question only if I like your question. You can do that. You can do that. Absolutely. Yeah, they're trying to intimidate, and we are pointing out, we have given you the website, that it's a voluntary, please follow the direction.
Sai has a question about an H-1B transfer that he has in process, and he has a job offer from another employer, and he wants to know, can you file an H-1B transfer without the current pending application being approved? So that really depends on whether your current I-94 is still valid. If, Sai, your I-94 with your current company is approved and still valid, it's unexpired, and you have maybe a transfer ongoing in the background. If you are still working according to a valid, unexpired I-94, then you can have another company file a transfer for you in parallel, and that's fine. It can be approved. It won't interfere with the other transfer that's pending. They don't even need to know about each other. You don't necessarily need to include the receipt notice of the pending transfer if you don't want the other company to know about this other job offer. That changes if your I-94 has already expired and you're in a period of authorized stay. If the pending application is what is keeping you in a period of authorized stay, basically you don't have a valid I-94 anymore, but you're able to keep working because the transfer was filed before your current status expired, then you could still have the new company file a transfer at this time without the approval, but be aware that USCIS will probably send you an RFE asking for the approval of this current pending application before they make a decision on the brand new application. Because at that point, this pending application becomes a bridge application. It becomes the outcome of this bridge application determines whether or not you are in status at the time the new transfer is filed. And so if you do decide to do those kind of concurrent filings, maybe make sure that this current pending application is approved. That would be safest, to make sure it is approved before filing another transfer.
Narendra has this follow-up question, which is interesting actually. It's bringing a lot of good questions to us. What if I'm not there when the site visited my home? I'm traveling outside. Follow the direction, my way or highway. When you're out of station, though, they will pressurize you. Answer my question within 2 hours, within 1 hour. By end of this day, you answer my question. That's how they are going to dictate the terms. I want you to tell them, no. Only if you eat my biryani, I'm going to, and if you're going to be nice, I may answer your question. And that too in a given time that is more suitable. Follow the direction, my way or highway, you will be in a very good position. Question that comes out was from a person who has that is Jyotirmaya. She has an H-1B, I-140 approved, and now she's an Australian citizen. What are the ways that she wants to move back to USA? Well, you do have an E3 visa option too, but we do not recommend E3 visa option because you have an I-140 approval. Even though it's old, you can probably overcome that. The best way for you actually would be to come back on H-1B. You may ask a question. I was not on H-1B for past 7 years. My I-140 was approved 15 years ago. How can I still come back on? My I-140 was approved like 10 years ago. How can I still come back on H-1B? Yes, you absolutely can come back on H-1B. You have no problem. Come back on H-1B. That will be the easiest thing. E3 has an extra burden for you to prove that you're not going to immigrate into the United States. But when it comes to the H-1B, even if they think you're going to come and settle here and you're never, ever, ever going to go back outside the USA and you will eventually get the green card because most probably your I-140 was approved long time ago, you might stay here. They still cannot deny your H-1B. But when it comes to E3, they can. And from E3, if you want to convert to green card, there are some issues over that too. So the best approach for you is to come on a work visa of H-1B. That's the best thing for you.
Satvik has a question about a 221G that he received about 11 years ago. And the visa at that time was denied because the employer was unable to submit the documents that were requested. And he has a new H-1B approval this year and wants to know on the DS-160, does he need to mention the previous visa denial? So yes, if the question on the DS-160 is phrased, have you ever had a visa refused or denied? You do need to answer yes to that. Although if it was that long ago and if it was kind of a result of something to do with that company that is completely unrelated to the new H-1B you have approved, I would say that previous visa denial won't really have an impact on your new H-1B visa application at the consulate, but you do need to disclose it. You do have to answer yes to that. Also, in a case where this isn't Satvik's case exactly, but in a case where you got a 221G and then you waited or provided the documents that were requested and it was eventually approved, technically just the issuance of a 221G is also considered a refusal, even if the visa was eventually granted. So it's also safest to answer yes to a visa refusal if you ever got a 221G, even if it worked out in that instance.
A question that comes from a person, Abdul Salim. He's on H-1B from Facebook. His father is alone in India. He's a sole caretaker. Can I bring him on? He's on H-1. We can bring him on B1, B2. Yes, you can bring him on B2, but you cannot keep him for more than 6 months, though. Unfortunately, even though you are a sole caretaker, there's no provision of H-4 provision for the parents or any other provision that can make you keep your father for a long term in the United States.
Sundeep has a question on his LCA. There are 2 work locations and there are big differences in the wage levels for those locations. Is it legal for his company to pay him a different lower wage than the one where he's working for a particular pay period? So Sundeep, the answer is no. If your LCA contains 2 work locations where the wage levels are different, the employer is required to pay you the higher of those 2 prevailing wages or the actual wage, whichever is higher. And
so
that,
Rebecca, let me ask you a question on that. Let's say, for example, I have a LCA location of San Francisco, and LCA San Francisco. Sometimes I work in San Francisco, and sometimes I work in Laredo, Texas. And San Francisco prevailing wage is 175,000. Laredo is 75,000. Every 3 months, I work 1 month in San Francisco, 2 months in Laredo. So what you mean to say is that since San Francisco is 175, Laredo is 75, even though I'm working in Laredo, the employer has to still pay 175. Is that what you said, Rebecca?
yes, that's right. Yeah, if both locations are listed on the same LCA, it has to be the actual wage or the higher. The actual wage is going to need to be higher than San Francisco's prevailing wage in that situation in order for the LCA to get certified. The LCA won't be certified otherwise. One way around that somewhat is, so if both locations are on the LCA, then there's no way around it. The company does need to pay you above the higher prevailing wage if both locations are listed on the LCA. But if it looks like you are really based in Laredo the majority of the time, and maybe your company headquarters is in San Francisco, you only go there, like Rahul said, once every few months for like a week or so to do meetings with your colleagues there. But really, the majority of your time is in Laredo. You can check with your company about filing an H-1B amendment so that your work location is only listed as Laredo. So when your work location is listed as Laredo, it doesn't mean you can never travel to the San Francisco office. There is kind of a short-term exception where if you are going somewhere for 30 days or less, it's not considered a work site. You're just kind of, you're sent there temporarily just to do some meetings or something like that. Then that's fine. But then your LCA would need to be, a new LCA would need to be filed with Laredo only as your work location, and an H-1B amendment would need to be filed in order to amend your work location to Laredo only to legally allow the company to pay you kind of that lower prevailing wage.
A question from Nicole Nuno. A week back, she asked a question about the 485 adjudication, and she got an RFE on medical, which is very good. That's a very good sign, Nicole, that if you got an RFE from medical, that means that most probably everything is good. They're ready to adjudicate your application. So you're pretty close to getting the green card. Question that comes up with regards to the location, work from home location. Very good questions are coming in. I mean, these are the things that make us better as a lawyer when you guys ask the questions like this. His question is that he's working from his home. Now the client changed. Does he need to file an amendment? Let's say he's working in Dallas. His client is in Atlanta. Now his client is moved to San Francisco, but he still will be working in Dallas where the LCA location is. Does he need to file an amendment? No. If the job duties are similar, most of the time it is. You do not need to, even though your client has changed from Atlanta to San Francisco, but you are still working in the LCA location, Dallas. You do not need to file an amendment.
Srini is planning to travel to Canada for a week. He has a valid H-1B visa stamp valid until the end of 2023 and wants to know, does he need a Canadian visitor visa to travel into Canada, or is he eligible to travel under automatic revalidation? So one thing to keep in mind about automatic revalidation is that it is a policy that it applies to your ability to re-enter the U.S. after travel to Canada or Mexico for a period of 30 days or less. It doesn't necessarily guarantee that you will be able to enter Canada or Mexico, because then getting into those countries is a matter of those countries' immigration policies. And so you do need to check whether you need a visitor visa to travel into Canada or Mexico. Generally, to travel into Canada, if your passport is from India, generally you do need a visa. So you give yourself enough time to apply for a visitor visa to get into Canada. Going into Mexico, it used to be that generally, as long as your H-1B or visa with the US was valid, you did not need a visitor visa into Mexico, although we did start noticing the past couple years that Mexican immigration was increasingly telling people that they should have a visitor visa. They've even stopped a couple of people who didn't have visitor visas to go into Mexico. So it's also a good idea to try to get a visitor visa into Mexico as well if you're planning to travel there. Automatic revalidation will definitely allow you to come back into the US without the need for a US visa. If the stay is 30 days or less, you have the valid I-797 with the I-94 attached. Getting into those other countries, you need to check on their immigration policies. And like we said, it's best to apply for a visitor visa beforehand.
Raj Mercedes has the question. What if there is a site visit? I'm outside the country for a couple of months. What should you do? Well, as I said, your way or highway. If you don't do that, they are going to command their way or highway. So you can say, well, just like this, if you get a donation request from Red Cross, okay, are you obligated to donate? No, you're not obligated to donate. It's up to you. Okay, I'll consider it. Once I come back, I consider it. However, though, these USCIS officers, they behave like goondas. You remember back in olden days, back in olden India, where they used to come and ask Mamul for Holi or Ganesh. They said they force you, they kind of intimidate you to ask the money. That's how the USCIS officer behave. But you need to treat them like very similar to the Red Cross. Red Cross people don't do that. They come and say, Rahul, can you give us some money? We are doing some good activities. If you say no, okay, that's fine. Can you consider later on? That's how. But these people are supposed to request you that way, but they don't. They behave like goons, and I want you to reflect this way with them. Your way or highway. Okay, I'm going to come. When I come, I will see, I will consider. That's all you can say. And only if they behave properly, if they do very good, you give them. Otherwise, don't encourage these gundas to do whatever they want to. Red Cross people never do that. USCIS people should not do it too when they come to FDNS. It's a voluntary thing. Just like you, whether you want to donate to Red Cross is a voluntary thing. Anything else, Rebecca?
No.
Thank you very much. If you have any questions, you can always consult me, Rebecca, or any of our 16 great lawyers that we have in our office. Don't forget that we do have a daily Zoom, daily conference call, free conference call you can attend. And we have provided the link for the FDNS. Please look into it. It says it's voluntary. Thank you very much. Thank you, Rebecca.